Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. And each and every Thursday night, this is where we need to be. This is where we need to be to discuss all things debt related, all the horrible things out there like debt collection, lawsuits, bankruptcy, wage garnishments, and really some ways and strategies and tips on how to deal with these particular type of things. So I am a bankruptcy attorney in the state of Arizona. I also defend people who are being sued by creditors, and every now and again we actually sue creditors for the things that they do that they shouldn't be doing. And so if you're in the state of Arizona and you need legal help, my phone number here is scrolling across the bottom. Feel free to reach out to me. I do free consultations. Unfortunately, I cannot help people who are outside the state of Arizona. I do have some do-it-yourself templates and tutorials. I'll put those in the notes below here that they can help you if you're not in the state of Arizona. But unfortunately, I can't do consults with people who aren't here because I'm only licensed in the state of Arizona, which brings me to my weekly disclaimer that you need to take this for what it is. Some guy talking on YouTube. If you need actual legal advice and you're not in the state of Arizona, I highly recommend you contact an attorney in your state. Sit down, go over your specific details. I don't know the laws in all states. A lot of things are similar, and that's why we can kind of talk in generalities here. But do that. And but if you do have questions, go ahead and put them in the chat section here on YouTube. And man, there's a ton already. We'll jump in. I'll put it up on the screen, and I'll give you some tips and strategies and maybe some approaches on how you can try to resolve it. So let's start with Al tonight. Hey, Al, thank you every week here supporting the channel. Al says he was served last Friday from Midland Funding, Midland Credit Management, junk debt buyer. Says the court records show that a notice of pending dismissal for lack of service was filed. No affidavit of service yet. Is this normal? This is a good question. And it leads to you'll notice on that the legal world and the court world, and each court, they kind of have their own way of doing things. The own way of trying to process all these cases because they're dealing in gigantic volume. Particularly in Arizona, the justice courts, they deal not only with civil cases like those filed by Midland Funding, they deal with criminal cases, traffic tickets, evictions, all kinds of stuff. So they have all these systems in place. What I see some of the justice courts in Arizona do is they will, as soon as the complaint is filed with the court, the clerk will immediately kick out a notice saying, hey, we're going to dismiss your case if you don't get it served within 90 days or 120 days, depending on the court. So they have a very limited amount of time to get you served. So it's not unusual that the clerk has sent this out. It's basically a notice to the plaintiff saying, you better get your job done, get them served, otherwise we're going to chuck this case out. And so that's why you may be seeing that, even though the affidavit of service, which is the document that's filed by the process server saying that they served you, even if they haven't submitted that, that's why you're seeing this particular notice from the court. You can call the court and ask them what the date is so you can see exactly how much time they have to serve you. It is important to note that if the case is dismissed for failure to serve you properly, it's dismissed without prejudice, meaning it can be refiled at a later date. And so I always say my advice, and this is something I always get beat up on social media about it on YouTube, is I always say, don't dodge service. Don't try to avoid it. Trust me, the courts across the nation have figured this out. They're going to let them serve you through an alternative method like the mail, or in the old days, they used to let them post it in the classified section of the newspaper. You're going to end up with a default judgment, and then you're going to be going to the attorney, and you're going to be really at a disadvantage. So hopefully that answers your question, Al. He follows up, says that he plans to file a motion to dismiss and compel arbitration. Do I need to file an answer or wait for the decision on dismissal? You can file a motion to dismiss right out of the gate. So if you get served with a complaint and summons in Arizona, you have 20 days to file a written response to it. Instead of an answer, you can file a motion to dismiss, say, hey, I want to compel private arbitration. Instead of going through the normal litigation process, if the court grants that, you're good. If the court denies it, then they're going to give you some additional time to file your written answer with the court. All right, Al, let's jump up to Taylor. Had a question I saw. She was here nice and early, saying that they sent a debt validation letter. I got to get up above I think it's called a chiron above the bubble. I sent this company a debt validation letter, and they got back to me. I found out that it's not a debt per se, but it's tort liability for $50,000. Should I offer to pay or just declare bankruptcy? And if I offer to settle, what's the lowest percentage I should start with? I was thinking since it's 50K, I'm going to start with 5K and up to 15K, yada, yada, yada. If no, they're going to end up in bankruptcy. So I can tell you this. So the fact that, and you did one other one saying that they hadn't served you yet. If it's tort liability, it's weird that there's like a debt collector contacting you. I would still ask for some written validation on the debt to see exactly what it is. Tort liability. So a tort is it's a civil wrong for which the law provides a remedy. I remember that from torts in law school many, many years ago. And so usually a tort is like if you're getting a car accident and there's some type of personal injury or a slip and fall case or, something like that. So it's interesting, unless you were in like a car accident and they're trying to come after you on that. That's maybe what it is. Negotiation is always a part of the litigation process. Nationwide, less than 2% of cases actually go to trial. 98% are settled. So you can always try to negotiate it. Depending on your facts and circumstances, they may go for 5K. My guess is they're probably not going to settle for $5,000. The decision to file for bankruptcy is something you need to talk to a bankruptcy attorney about, because there's no bright line rule of, okay, you have this much debt, so now you need to file for bankruptcy. A lot of it is your ability to repay, hardships you're going through, that kind of stuff will always play into it. I've always said before, I remember one time we filed a bankruptcy for a woman who had about $8,000 in debt, which is very low for a typical Chapter 7 bankruptcy filing. It might as well have been $8 million. Her income situation was such that there was no way she would ever be able to pay that back. And if she got hit with a wage garnishment, it would destroy her financially. She wouldn't be able to eat, kind of thing. So the bankruptcy made sense. But then I also see people who have over $100,000 in debt, and there's things that we can do to avoid the bankruptcy altogether because there's enough income. So kind of a case by case thing. But I would get some more information. It's a little interesting with the tort, unless they already got the judgment and then they're just trying to collect on it. So Tiny Limo was also here nice and early. They said, how do you request a court order? The clerk of the court was mystified by the question. I guess it depends on what the order is on. So usually the only time you're going to get a court order is if there's something pending before the court where you're looking for a ruling. So if somebody files a motion, like a motion to dismiss, to compel arbitration, and the other side has responded or hasn't, and you're just trying to get the judge to sign the order. Something that a lot of people don't know, particularly in the courts in Arizona, the judges usually don't draft their own orders. Often you have to draft the order that you want the court to sign, submit it, and if they want to change it, they will. Otherwise, they'll sign it and submit it back. So there needs to be an order in place, or a motion pending, motion for summary judgment, whatever it is. So you may want to call the clerk of the court back up and say, hey, I need an order on this particular motion, and then they can give you some additional guidance there on how they do it. All right. Jack says, good evening. Thank you for the live stream. Thank you, Jack, for watching. I sent my FTC identity theft and documents to the creditor's attorney in the court. What's the next course of action? Okay. I think this is a follow-up from last week when we talked about if you're in a situation where there's a debt and it has a true identity theft defense to it, where you're like, I just don't even know who this is. My information got stolen online. And, I've met people that have been just dealing with it. Getting your identity stolen is just a complete nightmare, as much as it takes to try to clean it up. And it's very difficult to do that. But I have seen it when I have a client who gets sued, particularly by junk debt buyers or even original creditors, and we go to them and say, look, the identity got stolen here. They'll give us this affidavit that the client fills out, submits to them. And then really it's kind of a waiting game. I can tell you this, that I would follow up with the attorneys. The court's not going to do anything with that initially. I would just keep following up with the attorneys for the creditor. And sometimes squeaky wheel definitely gets the grease when it comes to that, because most creditors' firms are relatively few attorneys, tons of cases. And so you've got to keep following up to be able to try to figure that out. So if you keep doing that, eventually they're going to give you a kind of a thumbs up or thumbs down on whether they're going to accept it. If they accept it, they'll go ahead and dismiss the case. make sure they're dismissing it with prejudice, meaning that it cannot be refiled down the future in the future. All right, let's see here. Tyrone said, I completed the motion to dismiss and compel arbitration. I was given a court date of August 25th. The plaintiff filed a motion to stay because I did not compel arbitration. Is there anything else I can do? I got to get a taller chair or something here. All right. So what I recommend in this situation is go back and get the terms and conditions from the credit card, the one that authorized arbitration. So when you filed your motion to dismiss and compel arbitration, like I said, some judges will just dismiss the case. Other judges are going to come in and they'll stay the litigation and say, okay, you guys go do arbitration. But if you don't do arbitration, we're going to come back here and we're going to litigate this thing. Here's the thing. In almost every terms and conditions for a credit card that has an arbitration clause that I have seen, it states that the party who has the claim against the other party has to initiate the claim. And so I always see creditors do this. They're like, okay, I guess we'll stay the litigation and let's do arbitration. And then they come to the judge and they say, oh, look, the defendant didn't initiate arbitration, so let's just litigate this thing. That makes no sense because they sued you. They have the claim against you. And so what I would do is before this August 25th date, that's next week, I would file a motion to dismiss with the court with prejudice, saying, look, judge, you ordered us to go and do arbitration. The terms and conditions state the party that has the claim against the other, they have to initiate it. And they didn't do it. And so they disobeyed the court order. So let's just dismiss this thing and be done with it. Because it doesn't make any sense. If you were to go to the AAA or JAMS, the arbitration companies that do this, you're not going to file a lawsuit essentially against yourself. You don't have any claims against the creditor. So it just doesn't make any sense. The way I understand what they're doing, they're kind of playing games here, but that's what I would do. I'd file a motion to dismiss and say they didn't comply with the court's order. And so by initiating the arbitration, so I would just have it be dismissed. So, all right, let's see here. See this one here by Uncle Deathy. Said you had a dismissal by arbitration, but now they're trying again, sending me letters again, what to do. All right, so you had a dismissal from the arbitration process. So it's unclear if you actually went through the arbitration. Oh, sorry, one of my lights just went out. Had a dismissal by arbitration, but now they're trying to send me letters again. A lot of it depends kind of what I was saying about this dismissal, whether it's with prejudice or without. That's what you need to go back and look at. If it was dismissed with prejudice and now they're still sending you letters, you need to contact an attorney who does FDCPA cases. Like I do those here in Arizona, because you now have a claim against a creditor for their failure to adhere to the court's order. If it was dismissed without prejudice, and assuming that the statute of limitations has not expired, then they can still try to collect on it. I should say this, even if the statute of limitations has expired, they can send you collection letters, but there needs to be something on there that states, hey, it's outside the statute of limitations, and so we can't sue you on this anymore. And if that's not on there and the statute is run, then you have a claim against them for that. So it kind of depends on how it was dismissed and what the kind of the next step is there for you. All right, let's see here. This one says, I was served. Shalonda says, I was served last Friday from LVNV. I submitted a letter of validation on 7/20. They sent back a statement and said they could resolve because it wasn't clear and to respond to them again. So one question I would want to know is when they actually filed their lawsuit. So if they served you last Friday, did they serve you before or after you sent your letter of validation? Because if you ask for validation, technically the FDCPA statute requires that they stop all they not continue to pursue collections until that issue gets dealt with. However, if they had filed their lawsuit in July 1st, you get served and then you send the validation letter, they can still continue. I would check that out. If they filed their lawsuit after you requested validation, I would, again, talk to an FDCPA attorney in your state and see if you can get this resolved that way. All right, let's see here. Let's see what Tiffany has to say. Can you still motion to compel arbitration even if they served summary disposition? There's no court schedule yet. Haven't even seen the judge. We just had mediation a week ago. Summary disposition usually means to me that there was a motion that has gone unresponded to. So maybe they filed a motion for summary judgment. If you didn't file a response to that, the court can just grant it. And usually what a motion for summary disposition is the attorney's way of trying to say, hey, judge, we filed this motion and you haven't ruled on it yet. So I would find out what that is first. I would read it carefully, see if it's referring to some other type of motion. And if not, or if you still have time, then yeah, you could file your motion to compel private arbitration. But you want to find out what that is specifically to see exactly what to do there. So, all right, let's see here. Someone says, if a creditor is contacting me 2 months after filing a Chapter 7, they're in violation of the stay, right? Yes, they're not only technically they're in violation of the stay, but they're also in violation of I should say this. So your case has not been discharged. Okay, so the creditor's if you file a Chapter 7, let me tell you how this works. So when we file the Chapter 7s, the bankruptcies are filed electronically. We literally click a button, sends all the documents to the bankruptcy court, and immediately I can log in and click on an order that's issued by the judge, and it's already in your file. And it's an order that says, hey, the case has been filed. It's actually called Notice of Bankruptcy Filing. And it lets the parties know that the automatic stay has now been entered and no collections are to continue. Now, the one thing I always say, if the creditor is still contacting you, double check that you included them in your what's called the creditor's matrix or on your schedules. Make sure that they receive notice of it. Because if their address isn't on there, then you're going to have to provide them notice and maybe amend your bankruptcy schedules to be able to show them. If they're on there and it's clear that they got notice, yes, that's a violation of the stay. The way to get them to stop is you can file a motion with the court where you're essentially asking the court to hold them in contempt. If you have an attorney, they can do that for you, and then that should stop. Usually before I, as an attorney, will file a motion for contempt or for damages for them continuing to try to collect on it, I will try to make sure that I'm on solid footing as far as that they got notice of it and then I listed them in the creditors. So that's one thing you want to check first, but then yes, you could pursue a violation of the automatic stay. So, all right, let's see here. See what George has to say. When the calls cease, does that mean they are preparing to arrange for legal representation and serve me? It's been over a month since the last attempted contact. This kind of calm before the storm. Sometimes that could be what it means. A lot of times with debts too, which you'll see, particularly once the lawsuit's filed, a lot of times they've changed hands multiple times. It doesn't, sometimes you'll see the original creditor to debt buyer, but sometimes you'll see original creditor to debt buyer to debt buyer to debt buyer to debt buyer. And then not only that, some of the debt buyers will kind of farm it out to different collection agencies where they're not actually selling it, but they're just hiring someone to do the collections themselves on it. So that's something to be aware of. And it could be just in between. They could have sold it to somebody else and they haven't started up their collections yet. It could be that they pass it off to an attorney. Sometimes I'm surprised. I'll see that the creditor will actually pass it off to their lawyer, and they might sit on it for a year until they actually get the documentation ready for the lawsuit. So, unfortunately, it's hard to tell, but you're thinking along the right lines. It could be that it's changed hands, and now you're going to start getting letters and calls from a different collector, or it could be that the attorney has it and it's just sitting on someone's desk, like all the papers behind me waiting for to get to it. So, all right, let's see here. I'll take some compliments here. Randall says, love the program and the courses. I bought the Master Consumer Warrior bundle. Thank you. Hope you put out more courses, materials, and paid events in time. I've done many jams, AAAs for myself and others. Awesome. Randall, appreciate that. I've been thinking about if there's another course that would be helpful. I haven't put out a new one in quite a while. They do take a fair amount of effort for me to put together. And so I want them to be helpful. And not only that, we charge for them. And so I don't want it to be something where you're just getting it. And I always say, I I don't want to cause any more harm by throwing fees or, attorney's fees or court. I want to make sure we can actually provide some good value. And so if you have an idea for something that would be helpful for a course, put it in the comments or shoot me a message. I'd be happy to consider that. So, all right, let's see here. See what Matt has to say. Family member had a credit card with a local credit union that is reporting a charged-off credit card as a charged-off auto loan. Okay, so if the information is incorrect, and that can make a huge difference when you go in to try to get a car loan, because they're going to look, and they run, particularly most lenders use Experian, and there's a different FICO score formula used for mortgages and car loans. And so the fact that they've coded that incorrectly is a big deal. So the way to handle that, sometimes the quickest way is just to reach out to the bank or the credit union directly, say, hey, you guys screwed this up, and see if they'll do it. Because sometimes that can happen like that. If they're unwilling to do it, then you can submit a dispute through the online portions of the credit reporting agencies like TransUnion, Equifax, Experian. That takes 30 days to get that dealt with. So if it's something where you are trying to buy a car right now and that's causing a problem, I would go directly to the credit union, make them fix it. If it's something where you have a little bit of time, you can do it through the credit reporting agencies. I think you can even do it through Credit Karma. And try to get that resolved. And that usually only takes about 30 days to be able to get that done. So, all right, let's see what else we have here. Let's see what Anita has to say. The CFPB, the Consumer Financial Protection Bureau, sent the statement from Resurgent. They claim they stopped all contact May 21. I also had a court date. I was not properly served. I found the information on the Maryland courts. So I can tell you one of the most common things I hear in my consultations with people is they have a judgment against them and there may be like a wage garnishment pending. And they're like, I didn't even know this thing existed, which I think Anita's talking a little bit about here. And then they go back to the courts and they see there's been this whole litigation process that they were unaware of. If you were not properly served, in Arizona, they have to drop it off to you personally or someone who lives in your house of suitable age and discretion, which the courts even says is teenagers, which is always scary if the teenagers are accepting service. But the law in Arizona says that that's how it can be. But if they served, the wrong home, if they never came by, if they left it with someone who doesn't live with you, that doesn't count. And you could go back, file a motion to vacate. I do have a tutorial on that. File a motion to vacate the default judgment so that you can move forward. So, all right. Let's see what Kirk has to say. Court in 5 days. Use my course to help prepare my defense weeks ago. I feel confident I can win. Any last suggestions or words of wisdom? Well, thank you, first of all, for purchasing the course. I'm glad it's helpful. And the reason why I did that is because if you have some understanding of what you're heading into, it's not as, terrifying. When I was a brand new lawyer, I remember the law firm I was working at, they assigned you to like a partner in the firm. I went to court with him, and court was just like terrifying to me until that first time I sat in there. I watched it for a while and I thought, I can do this. This doesn't look that hard. And there's a kind of a flow to it. You also realize that not even attorneys and judges, they're not perfect. It's not like you see on TV, at least not usually. And so my words of wisdom are to, one, be there early. Don't be late. Don't leave it till the last minute. I always do so much better if I show up to a hearing or a trial, at least, a half an hour early. I'm able to go in there. Maybe I can see what the judge is doing, how the judges, as far as their calendar is. And then it gives me time to kind of go over in my mind the things that I want to say. And then I do, I don't do it really as much anymore. I've done about 400 trials relating to debt buyers at this point in my career. But early on, I would actually shut the door to my office and I would out loud just go over what I want to say, like in my opening statement, make sure I'm going through my notes for direct examination, cross-examination, just kind of really just play it all out in your mind. But my number one thing, be there early. As simple as that sounds, that alleviates a lot of stress. So, all right, let's see here. Oh, hey, and Kirk, thank you for supporting that. I sincerely appreciate that. So, All right. Edward says, do they garnish wages in Texas after a judgment is entered? The last I checked, there is no wage garnishment in Texas, um, which is always kind of bizarre to me. One, I don't know how they collect debts. I mean, that's how most of the collections are done everywhere else. And Texas is just such a aggressive state in other areas of the law. You know, like the death penalty. They're constantly setting records there, but then they don't allow wage garnishment, which is kind of interesting. As far as I know, there's no wage garnishment there. Let's see here. Shalanda's helping us out. But they do allow the garnishment of bank accounts. And so you got to be careful with that. Sometimes that can even be more brutal than a wage garnishment because there's limitations. Like in Arizona, they can take 25% of each check that they garnish. But in bank levies, like in Arizona, if they hit your bank account, they can take all but $300. Shonda is here for us today, but they don't garnish wages for debt claims. And that brings up something that's interesting. There is a proposal that's going to be on the ballot in Arizona in November, where they're trying to change, like, up the homestead exemption from $250,000 in equity up to $400,000. They're going to reduce wage garnishments down to 10%. They're going to make the exemption for vehicles jump from $6,000 to $15,000. I'll post some information on that. I may even do a video on that because that would be a game changer in Arizona. And it's no surprise. The junk debt buyers have created a lobby in Arizona, and they're fighting this tooth and nail. But right now, it's going to be on the ballot, and I think it could be a really good thing for Arizona. So, all right, let's see here. If you lose a case, is it worth taking it to the Court of Appeals? And the Virginia Court of Appeals has to hear all civil cases. Now, the appeal process, it kind of depends on why you lose, which I know the it depends thing is what the answer that people hate from lawyers. But here's the advice I give on appeals. The important thing to understand on an appeal, when you appeal a case from the trial level courts, the Court of Appeals, what they're looking to see is if the judge at the trial level did the right thing, if they applied the law correctly. They're not retrying it. You're not going to be able to bring in new evidence that it wasn't heard before. Essentially, in most cases, in most of these junk debt buyer cases, they're going to be looking to see, did the trial judge, did they abuse their discretion? Because the judge is given a little bit of discretion, actually quite a bit of discretion in cases, to apply the law. And I've heard appellate judges say, look, I agree. I don't think that if I were hearing this case, I would not have ruled that way. But the ruling is not so far out of the bounds that I think that it's not within a judge's discretion. So that's what you really need to look at is, did the judge just flat out get it wrong? Or is it the judge just had a different opinion than you? And understanding that if you go to appeal and lose, the creditor may add additional attorney's fees onto there. So you got to be really careful. That's when you need usually an attorney to evaluate it to determine if the appeal is going to make much sense to be able to get it done. So, all right, let me see if I can get a couple more in here. Let's see here. Oh, Randall's giving me an idea for a course. Purchase a response to stay the motion to compel on what you mentioned. That'd be a good idea. I could probably even put something like that together and just add it to the course. And if you've already purchased it, you would get access to that. Not promising that's going to happen today. It'll take me a while to get that put together and uploaded, but I may be able to do it. Let me do one more question for Nita. Do they garnish Social Security retirement in Virginia? No, nobody does. Social Security, income received under the Social Security Administration, whether it be Social Security retirement or disability, it's exempt under federal and state law, and they cannot take it. So, all right, let's see here. Hey, Shalonda, don't you worry. I want you I need help. I'm trying to go through that. I'm trying to scroll my computer, and any help you can do, that would be awesome. So, all right, let's see here. Oh, and then Randall's got one more. Sending custom design legal T-shirts and swag for your team. Don't tell me I'm not anywhere near a small. I haven't been a small since I was a baby. So, all right, we're going to wrap it up here. We've been going about a half an hour, and I got to get home tonight. So, hey, everybody, thank you for checking in, and I appreciate all the questions. And Shalonda, I appreciate all the help. that everybody's given me. I'll put some links to those tutorials I do put in there that they can be of help. Check those out. We will do this each and every Thursday night. We're putting in a lot more content. I've got a great editor now. He's helping me out. But if you have questions or ideas for a course or whatever, put them in the comments. I do read them, and we will